Given the amount of people who are present, you can let's get started, because I'm sure that towards the end we're going to have a lot of questions. As you know, Yvonne, as I told you, we very proudly quoted your book in our brief that was filed last week, especially the section on the evaluation of oral evidence. And you discuss in your book the 14 source evaluation criteria extrapolated from the ICC trial judgments. Do you want to start and discussing about this as a general topic?
Yeah, sure. So first of all, thank you so much to the ICCBA for the invitation. I'm so delighted to join you today, and thank you especially to Judge Corner for joining in this conversation. So on source evaluation, this empirical work, it's not my own, it's work that's largely been carried out by Gabriele Cevlicate, Barbara Ola and Catherine Blieveld, where they consolidated what they call the ad hoc, consistently evolving jurisprudence on the evaluation of oral evidence into a sort of framework of factors that can be extrapolated from the case law. And I think this empirical research is so interesting and so valuable. And then Javier Aguirre Aramburu, who works at the Office of the Prosecutor, similarly did this source evaluation criteria. So it was him who came up with the 14, again extrapolated from ICC trial judgments on what things the chamber will take into account. So the fact that there are 14, it just indicates just how complex it is in terms of deciding what's relevant and important in deciding what weight to give to a witness's account. So it ranges on everything from consistency in their account to whether there's any indications of collusion or witness interference, whether there's a relationship between the witness and the accused, the witness's own bias and motivation, contradictions. A lot of the judgments talk about trauma and the impact of the passage of time. So these are things that will be taken into account in assessing the witness's credibility. Barbara Ola and Gabriele and Catherine in their research also talked about how some earlier judgments, we don't see it so much now, but there used to be occasional reference to things like the witness appeared evasive on the stand, or these failing to make eye contact and this kind of thing, and they point out that actually psychology research shows us that there are no tells or giveaways in terms of when we know someone is lying or not. And even if that were true, even if there were things like failing to make eye contact or appearing evasive, that in some contexts lead us to believe that someone's telling the truth. It's even more problematic in the context of international criminal trials, where we have very different cultures. We've got the language barriers, all these other factors that come into account. So that's the source evaluation criteria. I don't know if Judge Corner wants to say something about this.
Right. It's probably one of the most interesting parts of assessment of a case, and it's one which we're currently working on in my case. You will have seen the judgment guidelines, which were confidential until very, very recently, have now been made public and are attached to the Chamber's practice manual. The importance that is attached to witness assessment. And I think it's an ever-evolving topic, because if you read some of the earlier judgments, there's a lot about how the witness looked you straight in the eye and didn't hesitate, and so on and so forth. And of course, studies since then have shown that it's utterly misleading. In particular, when you're dealing with the cultural background that many of these witnesses come from. And also that, of course, it's not obvious if a witness is on video link, as more and more witnesses are on video link because of the difficulty of getting them to the court. I think an assessment is a combination, as Yvonne says, of a number of different factors. The length of time that has elapsed normally since the events took place. In our case, it's 20 years or so. And so you have to factor in that. When did they first talk about these events to investigators? What opportunity did they have to view it? Is there evidence? And that's an important factor, supported by other evidence or contradicted by other evidence. If it's contradicted, is that in a material way? And so these are all the factors that you have to consider. But by and large, because these cases still depend so much on witness evidence rather than documents, it's probably the most important factor that the chamber has to take into account when arriving at a decision.
I might just add two small thoughts to this. So one is, as some of you might be aware of, there's a book published a few years ago by Nancy Combs called Fact Finding Without Facts. And it was a book that really, I think, shook things up in terms of thinking about the evidentiary foundations of international criminal judgments, because what Combs did was she went back and she compared, you know, the same witness in different trials would give very like diverging answers on, and not just on like small details, but on key things like how many children do you have, like where were you living, you know, these things that you would expect some degree of consistency. And I remember a few years ago we had a conference where Nancy Combs was one of the speakers, and so was Teresa Doherty, who'd been a judge at the Special Court for Sierra Leone. And there was this quite heated debate where Judge Doherty was saying, you simply can't assess someone's credibility without having seen them in person. Like, it's the, you know, the person on the stand. And she had this example, and she later published this in the Leiden Journal of International Law, where she had a discussion with her legal officer about the credibility of a particular witness. And the legal officer said, well, I don't think that's right. This witness we can rely on because there are all sorts of inconsistencies in between their earlier statement and what they said in the transcript. And Judge Doherty said, but, you know, I had seen her, and on the stand, she was very sure of her facts. And I kind of thought, gosh, you know, well, it's interesting, isn't it? I don't know. Yeah, I think if someone even can seem very sure of their facts, that doesn't necessarily follow that they're telling the truth. So yeah, so that's, I don't know, Judge, do you?
I think actually there's been a very recent survey conducted by Professor Terrell Thomas of UCL about how juries react to complainants appearing on video link rather than in person. And it does appear from that research that the juries don't find it quite as compelling when the witness is not as in court. Obviously, there are a number of factors. Whereas I think particularly for professional lawyers, and that's what all judges, in one form or another, all judges at the ICC and the earlier courts had been, whether judges, lawyers, or academics, or whatever. And particularly since COVID, we're all used to receiving evidence on video link. And I think it's done away with many of the, in a funny way, many of the misconceptions that one had when they were there in front of you. So it's quite an interesting point.
There's something else I was thinking about, which is the, obviously issues with witness testimony are well documented, but I think sometimes the perceived objectivity of other forms of evidence can sometimes be overstated. So, sorry, I see there's a comment, I'll write that in a second. So in the book, I give the example from Lubanga of there was a former child soldier who'd given testimony, and the chamber in its judgment goes through all the reasons why this particular individual is not credible. And they said, we're not going to rely on this person's account, except for there was a video that was shown in court and she identified herself in this video. And they said, except for that video, because the video, it speaks for itself. So, in the book, I make the point that the idea that a piece of audiovisual evidence is free from subjectivities and biases is actually kind of problematic. We often see this idea that it's objective, the video or the image that's taken. And in the book, I give the example of there's a lot of research from the US on police body cameras. And so what you see when you see the footage from a body camera is the view of the person who's wearing the camera, and actually what's out of sight can very much depend on that perspective. We can also think about it in the context of war crimes, where, for example, someone might record a video but deliberately exclude something that suggests this was a military objective, for example. So yeah, objectivity isn't guaranteed, I think, in any form of evidence, not just witness.
Thanks to both for this. Let me quickly jump in the next topic. I know it's a topic of interest and debate for both of you. The burden and the standard of proof, including in no case to answer.
Yeah. So this is something I dedicate quite a lot of time to in the book, and the no case to answer. So I have chapter 4 is on the burden and standards of proof. As we know, there are different standards of proof for different procedural stages. But when it comes to no case to answer, just for, I don't know if you would agree with this, I think it's fair to say. Sorry, I got muted there. Maybe that's a sign. But I think it's fair to say that the case law is fairly inconsistent on this. So first of all, on what is the legal basis for no case to answer decisions? So there are 3 possible answers to this in the jurisprudence. One is that it's a function of Article 66, the presumption of innocence. Another is that it's a function of the trial chamber's ability to make decisions relevant to the ordinary conduct of proceedings. So that's 64(8), I think. And another is that it's Article 74. It's the final decision. So that's an element that's unclear. And the other thing that's unclear is what exactly is the standard of proof for no case to answer. So we'd had the Kenya cases, Ruto and Sang, where there had been a no case to answer decision, but it was a slightly different scenario to Bagbo and Blegude, because in the chamber in Ruto and Sang had followed the admission of evidence model. So they decided on whether a piece of evidence was relevant and had probative value and wasn't unduly prejudicial at the time that it was introduced. The chamber in Bagbo and Blegude had followed what's now known as the submission model. So everything had been considered submitted, with those factors to be considered at the end. And as a result, then, when we came to the end of the prosecution case and the defence made a no case to answer motion, there was a question about to what extent does the chamber need to now evaluate the evidence. The case law and the rules of procedure and evidence in the ad hoc tribunals had been very clear on this, that the standard of proof was whether this evidence, if taken at its highest, would be enough to sustain a conviction. But where we're at now is that and that was what Judge Henderson said was the standard of proof. Judge Sharfusser said it was beyond reasonable doubt. And the appeals chamber essentially upheld that. So the case law is inconsistent, to put it mildly. I don't think that that's right to say that the standard of proof is beyond reasonable doubt for reasons that we can discuss. But I also thought it was quite notable that Judge Sharfusser in his decision said, no case to answer proceedings have no place within the ICC statutory framework while issuing a no case to answer decision. So yeah, there's a lot of things that I think could be easily cleared up with an amendment, maybe to the rules of procedure and evidence, maybe to the regulations of the court on this.
Would you think that the confirmation of charges has an impact on that? That once a suspect went to a confirmation of charges and the charges are confirmed, it's part of the background as to why some judges will say that there's no place for a no case to answer at the ICC?
Sorry, was that a question from you? Because if it was for me, I didn't actually catch it, Milene. Sorry.
Sorry, I'll start again. So Yvonne just said that some judges are of the view that there's no place in the statute for no case to answer. My question is, do you think that because of the special framework of the ICC statute, including a confirmation of charges proceedings, which we didn't have at the ICT, do you think that this is one of the reasons for this opinion?
Yes, I do. Definitely. The discussion between the judges has been ongoing for some time, and indeed a suggested set of procedures was put before the ACLT to see if it go through, but it hasn't reached a conclusion. I think there are a number of problems. The first is a view that, as you say, the Rome Statute doesn't contain anything about it, but nor did the earlier statutes. It was the rules of procedure and evidence that dealt with, quite obviously, because it is a procedure, rather than an actual statutory provision. And that's not contained in our rules of procedure and evidence. And part of the reason undoubtedly is that for many of the judges, the confirmation procedure is supposed to negate any need for a no case to answer procedure. And for many obvious reasons which have appeared in the cases, and that's the difficulty, the test at the confirmation procedure is not the same as a trial. The evidence may change quite dramatically because you don't hear the witnesses most of the time in the confirmation procedure. It's simply done on paper, and evidence changes dramatically. But I think the main argument is this, the one Yvonne makes, that we've had a number of decisions, all of which in different ways are irreconcilable. And it seems that whether the civil law likes it or not, and it's one of the few divisions which I think still remains, it's become an accepted procedure in ICC trials. And it's about time, I'm afraid, that we try to regulate it so that not only the new judges know how to deal with it, but also counsel will know how it's going to be approached by the trial chambers. And my view is that, as Yvonne is, obviously, that beyond reasonable doubt is not the test at that stage. and it is something like a test of, is the evidence taken at its highest sufficient, although we're not using those words because that does come entirely from a common law view. So hopefully in the not too distant future, there will be an application to the states parties for an amendment of the rules of procedure and evidence, and at least some sort of basic procedure which goes into the Chamber's practice manual.
So maybe that's a challenge for the legal advisory committee. Speaking of the civil lawyers or civil law judges from a civil law background, my next topic is submission regime. What are some of the unique considerations in relation to social media evidence, open source evidence? When you look at, and I know that it's a heated topic in the current trials. I don't want to talk about the current trials, but when you look at today's conflicts, if there were to be a trial today, you can imagine the amount of open source evidence and social media evidence that would be made available to the prosecution or to the defense. What are the unique considerations you what would you have to say, and what impact could it have on the submission regime, which at some point can become very heavy, not only for the defense but for the judges who will have to deal with this evidence before issuing their judgment?
Yeah, I'm so glad you asked this, Malene. So, it's something, I guess the overarching argument is in this book is that international criminal evidence hasn't really developed as a coherent body of law for various reasons, including the flexibility that's inherent in the system. And, a function of this is the submission model, where we don't have these decisions on the admissibility of particular types of evidence at the time it's introduced. And in the book, I argue that really matters right now because we have documentation efforts of a scale and scope of that, we've never seen before. We're living in a time of the most heavily documented armed conflicts in human history. And so how one thing I do a lot is I get asked by various groups, can you tell us what do we need to do to preserve this evidence so that it's admissible before the ICC and so that it can be used in international criminal trials? And we simply don't have that guidance coming out from partly as a result of the submission model, that we don't have these individual decisions. So that's one challenge, I guess. It's the volume of evidence. There's this well-cited statistic that there were more hours of the Syrian conflict on YouTube than there were hours of the conflict itself. And so in that huge cacophonous online media environment, trying to find what's most relevant to your case and then verify it and, deal with all the other challenges like takedowns, like misinformation that can spread on, all those things is challenging for all parties in proceedings. There can also, I think, be equality of arms issues here. So where the defense maybe don't have the same access to technologies or external support as the prosecution. I think it's fair to say that a lot of the groups that are civil society actors that are busy documenting international crimes right now and sharing information are sharing it with the office of the prosecutor. I don't think there are that many who are doing things, preserving information, and then there's a similar, or there's a related issue around the sort of Article 55, the obligation on the prosecution, the duty to examine both exonerating and incriminating evidence equally. Well, how do you do that when what's exonerating and incriminating is potentially everything on the internet in relation to this conflict? And then that in turn can lead to issues around disclosure, because if you're having thousands of gigabytes of data dumped on the defence with no context or relevance, then there are all sorts of issues that can arise. So that's some issues around the collection of this kind of evidence and the volume of evidence. There are also issues, I think, around the evaluation of this kind of evidence. So as we know, often the source is unknown, or it might be that we can tell who's posted this video, but we don't know, are they the person who captured this video or image. And of course, there are well-documented issues with misinformation, I work on this big project here in Swansea on user-generated evidence, and I would say much more common than altered content is what we call misattributed content. So this is where someone posts a video or an image and they say, this is happening right now in X country, and actually it's from a totally different conflict years ago. A quick reverse image search shows us that that's the case. So my colleagues and I recently released this guide for judges where we talk through some of the techniques that are used to verify this kind of content. We hope it'll be useful, but we emphasize the need to look at the source, the content. So are there clues in the content itself, and the technical aspects, so things like metadata, chain of custody, and all of that.
Yeah, I mean, let's give Yvonne another puff, although she had some help on that one. The guide to the admission of open source is really useful, and it's worth all counsel who are going to be appearing in cases before international tribunals to have a look at it, because it is something that's likely to guide the judges. With regard to the original question, Elaine, about the submission form of putting evidence, documentary and other evidence in, I agree. It's going to add to problems which already exist, which is that the parties tend to throw the kitchen sink in under the submission system. Instead of being more selective, which they would do if they have to argue the admission of each piece of evidence at the time, they say, well, we'll just throw it all in, and the judges can sort it out at the end. The advantage to it is that it does make the trial process slightly more streamlined, because you don't have to stop, and indeed, the witness may not be able to carry on testifying while you argue whether a particular document or video or whatever is admissible under the strict rules. But I do think there's going to have to be an onus on parties to explain, particularly with bar table motions, which is where the sink really is thrown in, why the chamber needs to have this a particular piece of evidence. But as far as the question of evaluation of evidence, which is, as you rightly say, any cases which arise out of the conflict in Israel-Palestine or Ukraine are likely to contain, or indeed any modern case, are likely to contain very large quantities of open source material. And so, again, I think it's going to be important for the parties to limit it themselves, but also for the judges to make a careful evaluation of it. And at the moment, by and large, and as many of you may know, I did a mock trial for Swansea and the GLAN organization about whether or not I would admit a video. This was when I was still an English judge. And one of the things that I did say, and I think that's still true, is that you would be looking for evidence which in some way supported the accuracy, the authenticity, and could exclude the bias that Yvonne's already spoken about, that somebody deliberately films something from a particular angle, which cuts out material that may be important. So there's no way this is going to be easy.
Well, I think we've kind of come full circle, because I was just thinking about where we started in the evaluation of witness testimony. Again, like, I saw Nancy Combs speaking recently, and she said, you know, when you think about those, some of the cases in the ICTR about what happened in Rwanda in 1994, it was just, it's difficult to comprehend right now, but you would have like a witness who says, no, there was no rally in this town on this date. And this is a rally where like apparently 1,000 people came to. And someone else would say, oh yeah, no, there was a rally. You know, I heard about it on the radio, I went. And you're balancing, you know, different witnesses, different accounts, and there's absolutely nothing else to analyze other than the perceived credibility of each of those witnesses. Whereas if we think about today, really in any country in the world, it's very hard to think about a situation like that where you wouldn't have some way that through, you know, social media or through online open sources, you could somehow verify which of those accounts is correct, whether something of that scale and scope actually happened or not. And, you know, I was really struck in your final brief, Milene, about, you know, there was this issue about a video, and then you, through open sources, you were able to find another video that provided important context on what was happening in that video and what we were seeing. So yeah, it brings us back to this where we started when we were talking about corroboration. And
yeah. Not corroboration, that's a technical term.
The holistic evaluation of evidence. Yeah.
And in that case, the video was contradicting what prosecution counsel was suggesting. But yes, it is true that at the ICTRs, we barely had, we were lucky if we had a previous witness statement to confront the witness with perceived contradictions, or maybe sometimes some MILOBS reports. And we would say, well, the MILOBS didn't report any gathering or any special demonstration at that location. So, you know, the witness's credibility would be, you would try to impeach, but that's all we had. There was no smartphones. There was nothing. Let's finish the circle, as you say, Yvonne, before we give the floor to the audience for questions. You discuss in your book, you discuss Rule 92 bis at the ICTs. And you noted that in the Popovich trial, the trial chamber noted that it would be rare in the specific context of the tribunal for convictions to be based solely on 92 bis statements. We've seen the different decisions by various trial chambers on Rule 68.2. So I'd like to hear you both on that, because 68.2 is the equivalent of 92 bis at the ICTs.
Yeah, thanks, Milene. So in chapter 5 of my book, I give this example from Popovich, where Judge Kwan in his dissent had noted that the only evidence of a specific incident, so beatings and killings near the Kravica supermarket, was one 92 bis transcript. And, you know, the Judge Kwan argued that basically the sole and decisive rules should be applied in relation to each separate charge, not to the broader category of crimes, which are usually a number underpinned by a number of different incidents. So yeah, I talk about the appeals chamber basically disagreed with that, but I think Judge Kwan was right. I think that the evidence underpinning each specific charge in the indictment must be examined on its own merits. And if it can't be proven beyond reasonable doubt based on one uncorroborated, untested witness statement, even where you've got other similar charges that were established.
Yeah, it's great to see. I was just looking at your book, and because you mentioned Starkitch as well, which is, as you know, was my case. And the 92 bis witnesses were largely used for the background because, of course, there was a prohibition. You couldn't put in written statements that in any way implicated the acts and mens rea of the accused, and that doesn't apply in Rule 68 at the ICC. It's a difficult problem. I think by and large, when we were leaving aside 68.2C or whatever, which is the one where they're dead or although we did have an argument about unavailability and what that meant. The 68.3 ones, I'll stop there. 68.3, because the witnesses came and it was simply that their previous inconsistent statement, their previous, that's what the defense would like. The previous statement was just put in. But we haven't got that many in my case where we've allowed in statements under 68.2, and although and the 68.3 ones, although some of the statements, the previous statements did implicate the accused in acts or relevant to the mens rea, I mean, the defense had the chance to cross-examine. And I think, by and large, it's not often you get a really serious argument about it. I think, provided the witness is there and available for cross-examination, the fact that what they've said before goes in, I don't think makes a great deal of difference.
Yeah, I think it's just tricky because the examination is so limited where it is the sort of 68.2 type evidence. I'd also add to that, like, actually the European Court of Human Rights jurisprudence isn't particularly helpful on this. I remember in my fairness book, I have a whole section on this. So there's the Al-Khawaja and Tahiri decision on it's the sole or decisive rule. And basically the European Court said, well, you know, if there's other stuff, like even if it's evidence that wouldn't on its own sustain a finding of fact, then, you know, that sort of goes into the balance. And Laura Hoyano, who's at Oxford, has written an excellent critique of it called "What is Balanced on the Scales of Justice," where she says, like, that's not balance in favor of the defendant. That's just putting more things against them. So it's the opposite of balance. But this was the way that the European Court interpreted the notion of balance in this context. So yeah, that's where we're at.
Thank you both. Because there's now just 15 minutes left, I suggest we perhaps open the floor to the participants for questions. I guess you were very clear.
I think we've stunned everybody.
Where can we get your books?
Oh, thank you. Yes, let me share. Actually, I've got a discount code for 30% off. So let me share the link with that code. I believe also that the chapter 1 is available as open access at the moment on the Oxford University Press site. So let me pull that up and share it in the chat. Good question. Thanks, Lillian.
You're welcome.
There's a question for both of you in the chat. have you seen an evolution on the presentation of evidence along the years?
Okay, shall I start this out? Absolutely, absolutely, and not just in international trials, but in domestic trials as well. There's still an argument. There are still certain academics and certain judges who say that orality is absolutely paramount in criminal trials. I don't think that applies at all anymore. And I think orality, in some respects, it is not always satisfactory evidence, because particularly for witnesses who've undergone traumatic events, who are giving evidence years after those events, who are not used to court procedures, and confining what they say to what is relevant. Again, there's still a difference between how judges take witness evidence. Some judges much prefer the method of the witness should tell you absolutely everything in the way that they want to say it. Other judges take the view that it should be, if possible, limited to what's relevant to the issues in the case. But one way or another, it isn't the best evidence always. And I think that, as we've already discussed, whatever the problems by videos which are uploaded onto the internet, on the internet, Facebook and all other forms of social media, it can be extremely useful, because it is the most instant, if you like, or recording of something that's happened at the time. I may add, I forgot to add when we were talking about it, that of course one of the problems with the submission form of evidence is that and indeed all of this type of material is that the defense do not have the same resources as the prosecution. And I know there's been a lot of discussion about that. But I think, and I think the second thing is, which has changed enormously in my lifetime, is particularly in my domestic system, is intervention by the judges, control by the judges of the proceedings. When I first started as a barrister, judges very rarely intervened. If they intervened, they were appealed on the basis that the judge intervened incorrectly. Now, there are rules that say the judges do have the power, for example, to stop lengthy cross-examination, to put time limits on things. And I think one of the things that has certainly changed here in international cases is that there is less tolerance, I think, for time wasting and allowing not both defense and prosecution to go on forever. There is more control being exercised. And of course, for those of you who come from a civil law system, you expect the judges to control it, because that's what happens there. I've always enjoyed being a judge in a hybrid system because I do have more control.
There was some really good empirical research done a few years ago by Rosemary Byrne at Trinity College Dublin on exactly this, judicial intervention. So she went down, she took a team of researchers to Arusha when the ICTR was still at its heyday, and they were marking out, you know, how many times did this bench intervene, and tried to, it was really interesting because it depended a lot, I think, on the background of the presiding judge. You know, you did have chambers where no one said anything, it was completely party driven, and others where the chamber was really quite interventionist, asking its own questions of witnesses and so forth. But I agree, I think the ICC in general, all trial chambers that I've seen cases from, there's a lot more intervention from the bench. And the other thing I'd add is the other big difference is probably in the forms of evidence. So of course we've seen a lot about, or we've talked a lot about social media evidence today, but of course, although we had some satellite imagery stuff in the ICTY, for example, we're definitely seeing a lot more of that kind of content being introduced. For better or worse, I don't know. I mean, I think there was a lot of fuss made in Al Hassan about this evidence platform, and like you know, interacting. But actually, when you look at the judgment, it had a very limited impact on the ultimate factual findings. So whether we'll see more of that, whether I do think there's a lot of things to be considered in terms of what we do with a satellite imagery. The fact is, these are private companies that are creating this image-based evidence. What, you know, what do we see and not see is actually quite heavily mediated. So yeah, I think that's something that we'll see a lot more of in future proceedings. I can see lots of questions coming in on the chat, so I'll stop talking.
The flood has started.
Yeah, we've opened the floodgates.
The next one is for you, Judge Corner. In the context of international criminal trials, particularly at the ICC, how do you balance the rigorous standards of evidentiary proof required for the conviction of international crimes, with the often challenging realities of gathering evidence in conflict zones, where access is limited, witnesses may be at risk, documentation may be sparse or unreliable?
Well, it's a good question, isn't it? But I don't think I'm prepared to answer it in terms of my work here, because as some of you may know, we're about to deliver judgment. No doubt we'll explain in our judgment, and I'm not giving you a preview of how we've dealt with some of the problems, or how we assess some of the problems. But I think from my time at ICTY, it is one of the aspects of these trials which is troubling, but which, provided you are prepared to look at evidence that you might not otherwise have considered. At ICTY, where I was a prosecutor, we had some documentary film evidence through, for example, the reporters who went to the Amalska camp in 1992, and other reporters. I think you have got to be prepared to consider other methods of finding evidence, using perhaps more than you might otherwise, second-hand reports from UN organizations, reports from journalists, and the like, provided you are satisfied that even though, and I know this is an argument that goes on quite often about the hearsay element of UN reports, provided there is, again, and I go back to what I said, some support for that other evidence from either witnesses or other documents, or something that makes it clear that this is a matter which has been proved beyond a reasonable doubt. But it's one of the most, I agree, it's one of the most difficult aspects, and it does reinforce the need to look at all forms of potential evidence.
Thank you for that. Yvonne, you spoke about Al-Mahdi al-Hassan cases and the tool, the interactive platform, recreating the crime scene. So the question is about that, and the question is, however, some scholars argue that this kind of evidence is too persuasive and substitutes real memories of witnesses with the narrative of the platform. And others say that crime sites recreations are too traumatic for witnesses and will take too much time for all participants to analyze and use properly.
Yeah.
So what's your opinion about that?
Thanks, Anastasia. I was talking as you were typing a question on this. I hadn't realized we'd crossed over. Yeah, so there has been a lot of talk about whether, for example, virtual reality headsets could replace site visits and could help judges to assess the context in which the alleged crimes took place. But as you say, there are other sort of considerations to take into account. So Sarah Zarmsky had a very good article in the Journal of International Criminal Justice about this. I would just say, and you know, I feel like sometimes we can get a little bit blinded by science with these new high-tech developments. You know, when you look at Al-Hassan, so this Situ research platform was used to show the destruction of mausoleums, things like that in Timbuktu. But ultimately, he was acquitted of those charges because the chamber found that there wasn't enough evidence to show that he ordered the destruction of those platforms, that he was involved in that. So you know, often this kind of new types of evidence, new ways of depicting evidence can be quite good in showing what happened. But ultimately, when you're trying to determine who's responsible, I think we'll always need the old-fashioned witness, probably insider witnesses, things like documentary evidence, things like that. Yeah.
Can I just add that on my personal point of view as a defense counsel, whatever is allowed should also be used together with your client, because when we get on a case, he's the guide of the various locations or the various events, or and it's quite useful, especially when you have, for example, video evidence, where you're going to spend hours and hours going through every image, every individual, who's this, who's that, where are we, is this correct? So this type of platform, if ever used, could also be should also be made available for the defense team to look at, so the client can guide us. Next question. Would you say that public declarations of official state authorities could be sufficient to prove the intention to destroy a group in the case of a crime of genocide?
I really am not prepared to answer that question. I know what it refers to. I'm not
going to give a lawyer's answer, which is it depends. It depends on all sorts of things. So what other evidence there is, what those statements say. There's, you know, it's impossible to answer this question in the abstract.
There's a hypothetical here. If there are 24,000 victims of crimes against humanity, what would be the minimum number within that universe of cases would be sufficient to prove the systematic or widespread nature of such crimes? What are the parameters for such a determination?
Well, I mean, I can answer, I mean, from the ICTY case, apart from anything else. As we kept on saying, it's not a numbers game. You know, you can be widespread or systematic, and only have, you know, I don't know, say 100 people killed, or even less, possibly. It's a question of the area, the evidence which shows whether it was a plan, and all the rest of it. So the fact that, I mean, otherwise you might say, well, if the area is a really underpopulated one, or a country is, then it can't ever be crimes against humanity. And I don't think numbers, we kept on saying this in terms of Yugoslavia, and it just isn't a numbers game.
And in terms of the chapeau for crimes against humanity, it's widespread or systematic. So,
Yeah.
Yeah.
The last question for today, interesting question on protective measures. So let's move a little bit away from the evidence per se. How far can a court go in protecting vulnerable, at-risk victim or witnesses of conflict-related sexual violence by applying measures? Closed hearing, so in camera, for a victim of sexual violence or a child, non-disclosure of the identity of the victim or witnesses at the pretrial stage, standard of Rule 68 and the Lubanga case.
Yeah, I see it's addressed to me, but I think you've actually covered most. You can have closed hearings. The victim and witnesses unit do a fantastic job of dealing with the vulnerable, and indeed most witnesses, or not most, but many witnesses, whether or not the alleged crime is one of is sexual or not, require protection, one form or another. And so I see the question goes on, but and I see it's a very different question. So I mean, I think you've covered it by and large. I think the other aspect is where you have civil society organizations dealing with them or discovering them quite often, and there's all sorts of guidelines about how they should deal with these types of victims. I should add that, interestingly enough, the alleged victims of rape in the case I've just been trying were offered all the facilities of closed session, video link and whatever, and said no, they wanted to appear in court. So it's quite interesting. Yvonne?
If I may add, because I see the question indeed goes on and asks about, can the witness remain anonymous?
Oh, I see. I missed that bit. No.
There's a limit in terms, because at some point the defense needs to investigate on the witness. And I think there are measures such as delayed disclosure to the defense, and the defense can always suggest, okay, there's delayed disclosure, but you're going to put this witness at the end of your list, so at least once you disclose the identity, I have he's not first on your witness list. As you know, the prosecution can't call that witness first because the defense also needs time to investigate it, whether it's an alleged child soldier or a rape victim, on the identity of the person, the age, the circumstances, who, what, where, when. So to the question, can it remain, can we have anonymity, can the witness identity remain anonymous? No, at some point you'll have to disclose the identity.
Yeah, and I think there might be confusion here between anonymity, pure total anonymity, the defense doesn't know who this person is, and a protective measure is that the identity of the witness, their name, isn't disclosed publicly. Those two things are different. So,
Yes, absolutely.
you know, even like most witnesses are given a number, and that's they're referred to as that, even if they're not subjected to protective measures. So, yeah, there are two different things here.
Interestingly
thank
enough, sorry, I was just going to say very quickly that interestingly enough, you can't have anonymous witnesses from the defense in international cases, but you can in England and Wales. It's not often it happens, but you get completely anonymous witnesses where the defense do not know who they are, and it's caused many an appeal.
That's interesting.
Thank you both. Yvonne, I know you need to go, so and this was the last question. So thank you for your time and for answering all these questions very, very thoroughly, and for your expertise.
Thank you so much for hosting.
Thank you.
Everyone for coming.
Thank you all very much.
Thanks, Mr. Corner.